In a landmark case that could shake the foundations of South Africa's post-apartheid justice system, the Pretoria High Court is about to hear a deeply emotional and politically charged application. At the heart of this case are 25 brave individuals, survivors and family members of people who were kidnapped, disappeared, or murdered under the brutal apartheid regime. These victims are now demanding accountability from the democratic state that replaced the oppressive past. Specifically, they are seeking R160 million in constitutional damages, arguing that successive democratic governments, including those led by revered former leaders, failed to bring known perpetrators of these atrocities to justice. But this case has taken an even more dramatic turn. Two of the most iconic figures from South Africa's transitional era, former President Thabo Mbeki and former Justice Minister Brigitte Mabandla, are stepping forward, not as accused or defendants, but as intervening voices seeking to join the legal proceedings. To truly grasp the importance of this moment, we have to go back. We need to revisit the painful chapters of South Africa's history. The apartheid regime, which formally lasted from 1948 to 1994, was a system of racial segregation and violent oppression. Thousands of black South Africans and other people of color were brutally detained, tortured, and killed during this period. In 1996, shortly after the democratic government was born, the Truth and Reconciliation Commission, known widely as the TRC, was established. Its purpose was to investigate human rights violations committed during apartheid, both by the state and by liberation movements. One of the central ideas behind the TRC was that perpetrators who fully confessed their crimes could be granted amnesty. The hope was that, in exchange for truth, the country could begin healing without endless cycles of revenge. But the flip side of that agreement was equally important. Those who refused to come forward or failed to qualify for amnesty were supposed to be prosecuted. Unfortunately, that promise has largely gone unfulfilled. Despite detailed findings by the TRC, including names of individuals involved in kidnappings, murders, and torture, very few were ever charged. For years, critics have argued that political leaders simply lacked the will, or chose not, to pursue these prosecutions. Some say it was done in the name of national unity. Others believe it was about protecting powerful networks that continued into the new democratic order. And now, more than 30 years later, the victims and their families are still waiting. They are not only grieving the loss of loved ones, they are grieving the loss of justice. They are demanding answers from a state that, while not responsible for the original crimes, may be guilty of enabling silence, delay, and avoidance. This brings us to the current case. The plaintiffs argue that the South African government violated their constitutional rights by failing to take meaningful steps to investigate and prosecute apartheid-era crimes. They believe that the promise of justice made by the TRC and enshrined in the Constitution was broken, not once, but repeatedly, over the past 3 decades. They are seeking not just compensation, but acknowledgement that their suffering was neglected by the very state that promised a better future. But as the legal process unfolds, two powerful figures from that very transition, Thabo Mbeki and Brigitte Mabandla, are seeking to have their voices heard in court. According to their application, they want to provide what they call context to the court, to explain how and why certain prosecutorial decisions were made in the years after the TRC. Mbeki, who served as president from 1999 to 2008, and Mabandla, who was justice minister during key moments of that transition, argued that allowing this damages claim could create a legal precedent that oversimplifies the complex realities they faced in government. They're essentially saying that the court should not judge the post-apartheid state's actions or inactions without understanding the broader political and social landscape. They argue that transitional justice was not just a legal project, it was a political balancing act, trying to hold a fragile democracy together. But on the other side, lawyers representing the victims say this intervention by Mbeki and Mabandla is nothing more than a defensive move to shield the state, and themselves, from scrutiny. They argue that the real issue is not the political environment of the early 2000s, but the cold, hard fact that dozens of known perpetrators were never prosecuted. To them, this is not about revisiting history, it's about finally enforcing the laws and values of the present. And they warn that if the court allows this kind of intervention, it could open the door to further delays and distractions that will once again keep victims waiting for justice. This case is not just about compensation. It is about South Africa's soul. It's about whether we as a nation can still believe in the ideals that were supposed to define the post-apartheid era: truth, justice, and reconciliation. For many young South Africans today, the TRC is a distant memory. They were born after its hearings and may not fully grasp its promises or its failures. But the consequences of what happened, or didn't happen, back then are still shaping our society today. The failure to prosecute apartheid-era crimes has contributed to a wider culture of impunity. It has sent a message that powerful people can get away with terrible crimes if they are politically protected. And it has left wounds that remain unhealed in thousands of homes across the country. Human rights groups, both in South Africa and around the world, have welcomed this lawsuit. They say it represents a turning point, a chance to correct a historical failure. They argue that this case is not just about apartheid. It is about the universal principle that no one is above the law. If democratic governments can ignore the recommendations of their own truth commissions, what hope is there for accountability in the future? The court's decision on whether Mbeki and Mabandla can join the case will be a key moment. If they are allowed, the court will have to weigh their testimony and arguments carefully. If they are denied, the focus will remain squarely on the victims and the state. Either way, the outcome will send a strong signal about how South Africa intends to deal with the unfinished business of its past. As South Africans, we have a duty to remember. We must remember not just the horrors of apartheid, but also the promises made during the transition to democracy. We must ask ourselves hard questions about how we honor those promises today. Do we look the other way? Or do we fight, however late it may be, to make things right? This court case is more than just legal proceedings, it's a test of our national conscience. Thanks for watching. If you found this video insightful, make sure to hit the like button and share it with others who care about justice and human rights in South Africa. Don't forget to subscribe to the channel for more deep dives into important national issues. And let's continue the conversation in the comments. Do you think the state should pay damages to apartheid-era victims? Should former leaders be allowed to intervene in cases like this? I'd love to hear your thoughts.